Okay, you should all be able to hear me now. Good afternoon. Thanks for attending. I'm Ken Kirschenbaum. Today's February 15th, 2022. Today's webinar is, first of all, it's part of K&K's 2022 webinar series, which we're giving, and we have a bunch lined up for you, including one tomorrow that I'm also doing. And we still have room if anyone wants to give a webinar. I see a few people on here that usually have quite a bit to say. You're welcome to make a presentation if you'd like to. So today it's going to be a quick presentation. It's going to deal with the changes that we've made to the contracts, the updates that we've come up with, primarily through 2021. Even now going into 2022. So our latest contracts do have the 2022 copyright date on it, so we know what vintage we're up to, and you'll know what vintage you have if you've kept the copyright on. So let's get into some of the things that we've done to change the contracts. I did announce this year at our annual historical annual sale, since I don't want to commit to it in the future, but I did announce that this year we did have significant changes that were made to the contract, and therefore everybody was recommended to increase to purchase new contracts. Those of you that had made a purchase during 2021, of course, we're able to get the contracts either for free if it was within 6 months, or half price if it was within a year. So let's go through some of the changes real quick on some of the, well, not all of you use all of these different contracts. Let's see. The elevator contract, this is the elevator monitoring contract, and this year we added video monitoring option. Apparently, alarm companies were adding video to the elevators, and we've included that. And so we had to put in an elevator communication provision, and we had to include that in the monitoring service itself. So the monitoring service agreement was modified. We added this year a water valve shutoff provision, and this was a check box that was put in, and it was also then described within the agreement what water valve shutoff consisted of and what service you were actually providing in connection with it. And of course, we also came up with specific disclaimer provisions that I thought would be necessary for that particular service. And one of them is the utility shutoff, because the water valve installation likely required, some of the systems required, well, in all the systems required licensed plumber to come in, and in some cases required electrician as well. So, and also a shutoff of utility to the premises while this thing was installed. And so we want to make sure that we covered that in the agreement, dealing with the fact that there would be utility shutoff, and also the fact that some of the services that you were providing did require the customer to either allow you to bring in at their expense, or for them to engage a licensed tradesman to deal with the utility shutoff. The residential all-in-one for those Alarm.com dealers was modified. We added this connected car service feature that Alarm.com offers. But by the way, the water valve was something that I was alerted to with an Alarm.com feature that was added. So it was added to the Alarm.com contract and rider that we sell. But I then found out that the water valve shutoff was available from other places other than alarm.com. So that was added to all contracts. The Car Connect service, I believe, is an alarm.com feature. So we have that on the alarm.com rider and the alarm.com contract that we connect. So when we sell alarm contracts, if you've indicated you're an alarm.com dealer, and you get, which we figure out by you selecting that you want the alarm.com rider, you will automatically get the alarm.com contract version as opposed to the more generic residential all-in-one. All contracts were modified. The non-solicitation clause was modified. The severability clause and the arbitration provision in all the contracts were modified. They were updated. They had technical modifications to them and things that we needed. It does not mean that what you have in prior versions of the contract are not suitable. It's just that the updates we made make it just a little bit better. Okay. We did take out a provision that had been inserted in my contracts a while ago that said this agreement shall run concurrently with and shall not terminate or supersede any existing agreement between the parties unless specified herein. I don't know many alarm companies that were using that provision for any real reason, and it was causing some confusion. And we took it out, so it's not there anymore. So if you have more than one contract with a customer for the same service, you're not going to run afoul of one contract competing with the other. This was an important change in the lease agreements. And as you'll see it later, also even on the sale agreement, it comes into play. But on all the lease agreements, all the leases, we have a agreed value of equipment, which many of you are familiar with. And the earlier versions, well, I don't know, the 2022 change that was made during 2021 is we had a provision that in the event of the subscriber's breach of the contract, the alarm company had a right to sell the equipment rather than remove it for the agreed value. So what was happening is we were trying to use that provision even when there wasn't a breach, and we found that the language wasn't consistent with the way we wanted to use it. So we've changed it now. At the termination or expiration of the lease, the alarm company has the right to exercise the option of selling the equipment for the agreed value. Now, the exercise of that option should be done appropriately and timely when the expiration of that contract arises. Now, expiration of these contracts comes about one of two ways. One is the contract term runs its course. The customer or you give a 30-day notice that you don't intend to renew it, and therefore the automatic renewal does not kick in, and the contract comes to an end. The other way the contract comes to an end is that the subscriber breaches, stops making payment, or you've called in for another breach. Another breach could be that you never got a insurance certificate for an additional insured status, if you want to go that route and use that as a reason to terminate. But generally it's for non-payment. But now it's not just a non-payment. So the valuation of the equipment when you're first entering into this contract becomes an important issue because you are the value that you're putting on is generally I don't want to say it's an inflated number, but it's a number that would encourage you to rather sell it for that value rather than remove it. Now, that's not the case all the time. Sometimes you do want to remove your equipment for various reasons, and a lot of particularly in fire alarm systems, when you go to remove a fire alarm system, which by the way you might need AHJ approval to do or authorization to do, you are doing it in a way to coerce the customer or a new owner into signing a new contract and retain your services, because the cost of replacing that system would be much more than signing up for your continued service. Now, sometimes the valuation of that equipment is such that you'd rather sell it to them and be done with it. Maybe the system's causing too many problems, maybe the customer's causing too many problems, whatever variety of reasons there are, you've decided to move on from that customer. Generally, the valuation of that equipment is going to be a number that is attractive to you to want to exercise the sale option. Now, we get into a lot of discussion. What is the value of this equipment that we're talking about? What's the agreed value? Now, customers don't often think about what the agreed value is. They don't care because they're not paying for it when that contract is executed. They're not paying for it in their mind during the term of the contract. And a lot of them, and I'm not suggesting deception by any means, but a lot of them simply don't read or appreciate the fact that you do have the option of selling them the equipment upon termination. Now, what is the agreed value of this equipment? Well, it's not the agreed value of the equipment, it's the agreed value of the installed equipment. And that language is carefully selected by me because the intention is that the equipment has far more value once it's installed. We had a recent case regarding fire alarm equipment in particular, where we claimed that the fire alarm equipment actually increased in value over the life of the contract because that system was now grandfathered in, and the removal of that system would cause the building owner to have to install a new up-to-code fire alarm system, which would be a lot more costly than whatever was designated as the agreed value of installed equipment. So that was an argument that we made. It's a little harder to make that argument with security equipment, but even in that situation, a hardwired system might be very costly to reinstall, and that's what we're really talking about. We're not talking about the fact that the hardware itself has a value of $1,000 or $2,000, or in a big installation, perhaps more than that. We're talking about what it would cost to install a new system, and that would include all the equipment, all of the labor, and complying with all the recent code requirements. And we're talking about a much bigger number. So we have cases where you'll have an alarm system, whether it's fire or security, put in, and you'll see that it's, let's say they get $2,000 up front for installation work towards the installation, and we get $100 a month for the life of the contract, and you might see a valuation of that equipment at $12,000, $15,000, $60,000 if it's a big enough system. and that takes into account everything that's involved in putting this thing in and replacing it at some point. So anyway, that's the contract provision, and it was changed to give the alarm company the option to exercise that sale option when the contract has come to an end, not limited to when it's been breached. So that's an important change that was made. Another important change that was made was notifying the customer of termination of the monitoring services. Now, the earlier versions of the contracts did not require notice. So you were able, upon a breach or expiration of the contract, to simply terminate service. Most alarm companies were not comfortable with that. Most alarm companies wanted to give notice. Most alarm companies wanted to try and encourage the customer to stay on with them. And so most companies were giving notice. So what's happened is we changed the contract, and the alarm company now has to give a notice upon termination. So there'll be you'll give a notice. You can do it before, you can do it after, but the notice will provide that you're terminating service. Now, an important item in it is that the notice to your customer can be by almost any means that you can get it to them. So you can email it, text it, or send a letter. You will not find certified mail in any of my contracts, okay? So the clause is the same for all the contracts in all the states except North Carolina. Because in North Carolina, you actually have to tell them the statute that gives them the right to notice. So we include the statute and we stick it right in front of the same provision. So North Carolina, again, has its own little change, and we go ahead and we take care of that. That's one example of why we tell you that when you're buying residential contracts, that you very likely need a different form for a different state. So that's just an example of that. There were technical changes to the exculpatory clause, the insurance procurement clause, and the legal action clause. So the insurance clause, we added that the customer is going to provide proof of the additional insured status that they're required to get. So they're not only going to be in breach because they didn't get the additional insured certificate, but now they're going to be in further breach because they didn't provide proof. Okay, so that's one little change we made. On the arbitration clause, we had some other technical issues to make that provision a lot stronger. And one of the things that we added was that both parties are engaged in interstate commerce. And in this day and age, just about everybody is engaged in interstate commerce. It would be hard not to find someone who's not. Now we have, I guess, the single change that made me feel that every alarm company needed to upgrade their contracts. While all the other changes that I made are important, they weren't necessarily essential. But we added a provision towards the very end of 2021 that dealt with this supply chain difficulty and price increases. So at the end of 2021, manufacturers started sending out notices that said that the manufacturer had a right to change the price, not only on future orders, but on any order that you'd already placed that they hadn't delivered yet. So they had a right to increase pricing. You, on the other hand, were entering into alarm contracts with your customers, committing to a price and committing to equipment and various systems, and nothing in the contract gave you the right to increase your pricing. So that was a change of the times, and we had to therefore change the contracts. So we did. So we've now indicated that any price increase that you experience can be passed on to the customer. The customer agrees to pay that price increase. And if they don't want to pay that price increase, they are obligated to select and accept alternative equipment for the pricing that you originally gave them. So the intent is that you will not be stuck with the price increase. You'll be able to pass it on. That's the change made. I think it's an important one because particularly now we're experiencing price increases that are through the roof now, and that's not likely to change for a while. So that's a clause that's in there, and it's in there to stay. The delay, by the way, is already covered because the contract already has that you're not responsible for delays, which are beyond your control, and what's going on now is well beyond your control. So you've already been covered for that. This was another technical change that we made in the contracts. I don't know that this is not one of the essential ones, but we made it a little clearer that you had a right to terminate monitoring in the event of a breach, and that the customer owed the balance of the contract upon such breach. The language was there. It's sufficient in the older versions, but we just made a couple of changes. Okay. North Carolina has its own special language, but it's to the same effect. Okay, hopefully nobody on this call has a 3G problem, and if you do, it's your own fault. Waiting till the last minute, but thankfully your contract will not need any changing, because the contract already deals with, in several places, this issue, and we dealt with it way back in 4 or 5 years ago at least, when we went from 2G to 3G. We added language that you're not responsible for end of life of equipment, and you're not responsible for obsolete equipment or obsolete parts that you can't get anymore, and the customer needs to accept a substitute or replace the system. There's also, you're not responsible for discontinued communication pathways, and elsewhere in the contract it also provides that it's certainly the customer's obligation to provide the communication pathways. Now, for those of you that look to contradict me or find me making a mistake, yes, if you have your own radio network, obviously you're responsible to maintain it. So the contract does indicate that you might, in fact, own your radio network, and therefore you would be responsible to maintain that, although you would not be responsible for communication failures. Well, let me go back. This is an interesting change, and this is very recent. Years ago, well, I'll start at the end. We have restored in the sale contracts the leasing of the communicator. So years ago, communicators were separate from the panel, and the communication device was either a digital dialer or it was a radio, separate radio, and we would put a value on it just like we would with the leased equipment. So we always, the typical number that was used, the one we recommended, was $1,800. So the value of your digital communicator was $1,800. The value of your radio was $1,800, and the customer was required to return it, or they were going to be charged for it. Now the update of well, we took that out. We took that out, and I'm not sure why. I think there were problems with it, and it was taken out, but it's been restored. A lot of alarm companies that were using older contracts and now were updating their contracts started to say, hey, where's that $1,800 clause? So I said, okay, we're putting it back in, and I did. So it's back in. And of course, we've modified it now that you can exercise that right to sell that equipment, the communication device, at the termination of the contract for any reason, so it does not have to be a breach. Now, don't forget, a lot of people want to get that communication device back because they need to be able to stop it from communicating with the central station. So that's one of the reasons that we had such a strong provision in there to be able to get it back. But a lot of guys, maybe you don't need to get it back. You just want to, you'd rather just sell it rather than get it back. So you have that option now. We made some technical changes to the employment agreement because recent laws required it. There was a new immigration disclosure and refined restrictive covenant provision that's in there. So those were sort of technical changes. That's in the employment agreement, and you'll probably find it in the handbook as well. The employment agreement, we also added a full arbitration clause. Arbitration is becoming very, very popular with the industry, those that use our contracts, because when you have a dispute, we're able to deal with it here. My office is able to handle it for you, and we're able to do it quickly and inexpensively. It's a very important feature in the standard form agreements that we sell. The employment agreement had the arbitration clause in it, but we've expanded now to the full provision. And the reason for that is it's interesting that even though arbitration is favored by the courts, favored by public policy, you still get judges that simply don't get it and don't really want to give up the case and want to hold on to it and find any reason they can, and there's huge delays and everything else. But it really works well when it works. I'll tell you what we had just today, hot off the press. So we have a case, a fire alarm that we've sued on, and it's a leased system, and it was installed, and the customer claims that the fire alarm company did not actually complete the installation because the fire marshal, fire department will not approve the system until additional work is done. They want an extra boiler in another part of the premises hooked into this fire alarm system. That was not part of the original plan. It was not part of the original proposal, and it's not in the agreement. So a dispute broke out, not only who was going to pay for that extra work, but more importantly, the landlord in adjoining space was giving the subscriber a hard time about getting access to get into the boiler area. So that was a problem, and it was turned over, and we started an arbitration, and that was roughly 4 months ago. It's been taking some time to get where we are. The customer's lawyer continuously asked for adjournments and cited health reasons, first hers, then the customers, and all other nonsense. So anyway, the case is scheduled as it happens, this Friday. Now this is a $100,000 or more case, and yesterday the customer's lawyer runs into court trying to get a stay of the arbitration, claiming, well, they never signed the contract. They didn't sign all the contract. They signed one page, not the rest of it. The court has to determine it, that the whole arbitration should be stayed while the judge decides. So we opposed it, and this morning we were on the phone with the judge. Thank goodness to remote technology, and the judge laced into the customer's lawyer for making such a late effort to try and stop the arbitration, and the judge flat out refused to stay arbitration and criticized the attorney, and we fully expect this matter to go forward on Friday, and we also fully expect to get an arbitration award and win the full amount. So you couldn't get that in a lawsuit. In a lawsuit, had we not had this arbitration clause in this particular case, we probably would have been looking at 2 or 3 years worth of litigation. And that, by the way, that was pre-COVID time, that kind of timetable. Who knows what it is now? We have an arbitration that managed to get stayed over 3 years ago, and the judge has not ruled on whether or not it should proceed or not. We're about ready to go crazy on this particular case. So that's another $100,000. Actually, our legal fees on that case are now over $100,000. Which, but don't worry, we didn't charge it to the alarm company, but we are going to ask for it if we're permitted to go forward with arbitration. And that case, because that case only involved around $30,000 or $40,000 for a security system. Okay. Other changes, the asset purchase agreement. We have a form for that for you guys that want to DIY your own deal, which of course I don't recommend. And both the short form and long form asset purchase agreement does have a warning on it that you're better off with a lawyer. But we added some provisions when we gave these forms out. We left out provisions that we thought, well, maybe they're a little too technical. Maybe these are things that really shouldn't be put in without a lawyer involved. But anyway, so we've a number of alarm companies, a lot of them have purchased these forms, the short form and long form, and we've had to work with them. So we get deals sent to us, you know, can will you represent us on a deal? I say, sure. Okay, here's our contract. Boom. And we see the short form contract kicked back to us with check boxes everywhere. And of course, now that we're representing somebody in the transaction, we want to make changes. So I just felt, you know what, the changes that we want to make, which to us are routine, let's just put it in the form. So that was upgraded at that time. Okay. Contract updates and negotiations. Join the concierge program, folks. There's a whole lot of you on here. Some of you are concierge clients. Most of you are not concierge clients. What are you waiting for? Join. You get 10% off on contracts, including a sale price. You still get 10% off. You get a free half hour every month for contract negotiations, and you get a free collection letter, and you should be doing it. Okay, get your contracts on our website, which you already know. And now I'm going to get into the questions, because I know we have a few, and I'm sorry I wait up to the end to try and answer them. But here we go. Okay. Okay, I'm asked by a fire guy about fire door inspection. Recently in the articles, we had someone ask the question, will the contracts start to include fire door inspection as part of the fire alarm inspection service? The answer is no. If the fire alarm inspection service does not actually specify each and everything you're going to do, unless you're including it in your proposals, but you're simply required to comply with whatever AHJ checklist there is for the inspection. So after a little back and forth, we've been educated, we meaning me and hopefully you, if you read the articles, that it's been determined that the fire door inspection is not something that alarm companies should be doing, not unless you're trained to do it. But it's not a fire alarm company responsibility to check fire doors. That doesn't mean you're not responsible for devices that monitor the opening and closing of those doors, because obviously that's part of the electronic fire alarm system. Okay, but we're talking about doors themselves. We're talking about automatic closing devices, maybe door openers. You know, you have to be able to push the door to get out. So that's not included in the alarm inspection. Okay. Here's a question. Rather than using the term equipment, would it be better to use the term installed system so as to indicate that the value is the equipment as it was installed in the premises? Well, we do use the word installed. I'm not sure we use the terminology system or equipment. I'll look at that, but I think we say the agreed value of the installed equipment. Because equipment is probably broader than the word system. But anyway, that's that. The only ones interested in that kind of technical language are us on this call. Here's a question. What if they own the equipment and there is a built-in DAC? Is the software? Well, the communication device, when we refer to communication device as being owned by the alarm company, we do say that includes any software. So that part of the software that deals with communication would be included. How you would, I think the problem was, and the reason it was taken out of the contracts a while ago, was that all of the systems had a panel which included the communication within the software in the panel. Now I understand we're actually going to other outside devices, radio, cellular, I suppose. I'm not sure about digital dialing, but I don't think we're going back to a separate dialer, but I don't really know that. So we put it back in anyway. Is there a provision dealing with asbestos and lead? The answer is yes. We do have a mold and hazardous conditions in the contracts that are calling for installation, and the alarm company, of course, is relieved of any responsibility for that and doesn't have to work in those conditions. Where in the fire all-in-one can one find the supply issue? Well, you're not going to find it unless you have an up-to-date contract. And if you can't find it, then you're gonna, where would you find it? I'm not sure exactly which paragraph it's in. It might be in the delay paragraph. I think it's probably in the delay paragraph, but I'm not positive where it is. But it's there. And if you don't have an updated contract, it's not there. That's something we put in at the end of 2021. So if you bought it before then, before November, before October for sure, you don't have it. You need to get it. It should not be part of the fire alarm inspection, fire doors, right, or a separate contract. Training is not an issue as it is an NFPA code. There's no particular license required. It is not alarm inspection, it is door inspection. There may not be a license required, but I believe that might be training required. the fire department may require it. I would think that the guys that do fire protection work, which means devices that put out fires, or and prevent, like a sprinkler system, I would think that they more or less would be charged with including fire doors and their operation in their inspection. But I'm not sure. There are there may not be a license for it, but there's definitely certifications for it, and there's training too. Okay, so it looks like I'm out of questions and not quite out of time, but no reason we need to go the whole hour. I want to thank all of you for attending. I want to remind you that we have a webinar tomorrow on another topic, and I can't even remember what it was. I had an interesting day today. I attended a hearing from the New Jersey License Board for some fellow that was trying to get a license, and they were sort of giving him they wanted to question him at a hearing. So I had a little less preparation today than I would have liked for this, but that's what I was busy with. So again, I want to thank everybody for attending and all your support and all your questions and all your ideas. And if anybody wants to participate in a webinar or run their own webinar, they should let me know, and we'll be happy to do it. So have a nice day, and thanks.